Will you get in trouble if you name your characters after famous characters from an older book or film? Hi, I'm Gordon Firemark, and this is Asked and Answered, where I respond to questions from industry professionals so you can take your career and business to new levels of success. So Clark is an aspiring author. He's working on a high epic fantasy novel and has a question about characters after he's read some of my posts. They come from the King Arthur and Robin Hood stories. Here's what he wrote. In the fantasy world I'm creating for my novel, there's a kingdom where the names of the kings come from King Arthur's Knights of the Round Table. These names are spelled exactly as they are in the Round Table stories. Only the names are used. There's no other connection to the characters of the Arthur mythology. Is using these names a copyright infringement risk? Well, Clark, the short answer is no. I can confidently say that there is no risk of using the names of Arthur and Lancelot and Guinevere and Merlin and so on in your book. At least not any legal risk. Now, some publishers might feel that it's too derivative or whatever, but that's an artistic decision and it's best left to artists and marketers and publishers. So there are actually a couple of levels to this. First off, those characters in particular were initially created in the 1680s or so. So any copyright protection for the stories where they appeared has long since expired. In fact, at that time in England, there wasn't even a law that's equivalent to what we now call copyright that protects the work of authors. That law in England was called the Statute of Anne, but it wasn't enacted until 1710. And when it went into effect, protection lasted for 14 years. Now, modern copyright law does protect things for considerably longer time. Something written nowadays would last under copyright protection for 70 years after the author's death. So even under modern approaches, it would still be expired, the copyright in the Arthur stories. Now, that wouldn't be the case for characters from works that are still protected under copyright law. So you do want to be cautious about more modern materials. But there's another wrinkle and another aspect here. Character names aren't really protected very much by copyright. Copyright requires originality in order to get protection, and names like Arthur and Merlin probably don't qualify. Even for less common sounding names like Guinevere or even Lancelot, for example, those are only a small part of a much larger whole. So if you're using just the name, a court's probably going to find that taking those is what we call just de minimis. If you're not taking storylines or characteristics, the courts don't want to be bothered with finding justice over the taking of something so small. But you do need to be aware that when using certain kinds of character names, you could have issues. For example, Harry Potter is a trademark. It's protected against any use that would cause a likelihood of confusion among consumers. So if you were to write a book about a character named Harry Potter, people might think it was either written by or authorized by J.K. Rowling, and there would be that confusion. And she has pretty obvious strong reasons to want to prevent that. But even that protection has limits. If your characters Arthur, Lancelot, Merlin, and Guinevere are sitting around talking about their favorite book, and it happens to be that they mention Harry Potter, that's okay. That's called a nominative use, where you're just mentioning the thing by name and not identifying it as belonging to you or something you created. But this starts to take us down a pretty deep rabbit hole. So let me just suggest, if you are going in this kind of direction, you're going to want to consult a lawyer. And that about wraps it up for this question. But if you have one you'd like me to answer here, head on over to firemark.com/questions. See you next time.